Hello and welcome to this episode of the AML Clinic Podcast. I'm your host, Michelle Clement. In today's episode, we're diving into the world of anti-money laundering supervision and what it could mean for law firms if the FCA were to take on a bigger supervisory role. We'll be talking about how the FCA approaches AML oversight, how senior accountability works under the SMCR, and what firms can do to prepare. My guest today is Chantelle Obatolu. She has extensive experience in financial services, regulation, and compliance, and will share practical insights that law firms can learn from right now. Chantelle is a financial crime specialist and a visionary in bringing AI into compliance. As an assistant vice president in AML at Sumitomo Mitsui Banking Corporation, a leading global bank across 40 countries, she has spent over 8 years at global banks and consulting firms, tackling complex KYC, sanctions, and risk challenges. Chantelle is also a published Financial Times writer on AI, compliance, and human judgment, as well as an ICA speaker, known for blending sharp regulatory expertise with fresh, relatable storytelling on LinkedIn. Welcome to the AML Clinic, Chantelle.
Thank you, Michelle. Thank you for the introduction.
I really appreciate you making the time to come on the show. I'm sure it's going to be a fantastic discussion. To set the scene, Chantelle, how would you describe the FCA's overall approach to AML supervision?
Okay, so great question. Based on what I know and what I have seen, I would say that they use an approach of a risk-based approach, a data-led approach, and an outcome-focused approach. So we do supervise under the MLR 2017 Act. So we go beyond the policies in place. So the main questions I say we tend to ask, or well, FCA tends to ask, are: do firms understand their financial crime risk? So that is an important one. Do you understand the risk of your firm? Are controls in place proportionate to those risks? And do the controls work in practice? That is like the main focus. Are your controls something that work in practice? So it's treated as more of a core conduct issue rather than a technical exercise. I would say that would be the approach that they take right now.
What you are describing there sounds very similar from an SRA perspective as well. Focus outside of policies on papers towards understanding risk, proportional controls, and whether they actually work. Can you give us any insight into what FCA supervision typically looks like in practice, and how much can that vary from firm to firm?
The FCA looks at, well, I would say it's not really one-dimensional. They tend to take, like, it really depends on the firm, to be honest. So from a desk-based approach, looking at it from a desk-based approach, you'll look at policy requests, risk assessments, like SRA data and management info, that type of thing. And then, like, if they're doing a visit, say that they need to do a visit, it would most likely be on site. And then nowadays with technology, it would be virtual. There'll also probably be like interviews with senior management and like testing of files and systems, that type of thing. And then there'll also be thematic reviews. So the common risks, it would mostly be like that type of review. So one of those three things, but it would be a mix of approaches. I wouldn't say there's a single type of approach. It really depends on each firm and how they work and how well they conduct their risk assessment and so on.
So what you've just described there, the mix of desk-based reviews, on-site or virtual visits, interviews with senior management and testing files and systems, actually sounds very similar to how the SRA supervises law firms.
Yeah, I'd assume so that it would be quite similar in that instance.
So you mentioned speaking with senior management as part of that process, which brings me to a related point. Under the FCA, the Senior Managers and Certification Regime, or SMCR, really emphasizes individual accountability, something that might not be familiar to everyone in law firms. So, just to give our listeners a quick overview, the SMCR basically ensures that someone is always personally accountable for what happens in a firm. It was introduced for some financial institutions in 2016 and then extended more widely in 2019. So, my question is, what does the SMCR mean in terms of the day to day reality for MLROs and compliance leaders under the FCA?
With the SMCR, I would say that it's more responsibility and increased individual accountability. So it doesn't necessarily end with like delegating tasks and just like demonstrating oversight. You'd need to like show challenge and like how you would escalate something and how quick you escalate and show the follow through of your assessment.
What you've just described, the increased responsibility, individual accountability, demonstrating oversight, challenging decisions, and following through on assessments actually sounds again quite familiar to what we see in law firms through the MLCO and corp roles. So, for those listening who may not be familiar, the MLCO or Money Laundering Compliance Officer and the COLP is the Compliance Officer for Legal Practice are both personally accountable for ensuring their firm's compliance with AML and regulatory obligations. So, like the senior managers under the FCA, these roles require firms to show that responsibilities aren't just delegated. There's oversight, there's challenge, and proper escalation where needed. So that's really interesting. Building on that, I'd like to shift to remediation. Once the FCA identifies an AML issue, I don't know if this is something you've experienced personally. How quickly does it expect firms to act? And can you give any insight into what good remediation looks like in practice, please?
Yeah, because I've worked as an analyst and quality checker and so on, I am familiar with remediation, and I
Mhm.
do know that it's prompt action. Like they expect prompt action and they
Right.
expect remediation to be done well. So
Hmm.
I would say that they expect you to take ownership for whatever the issues have been identified, like do a root cause analysis, give a timeline of when it should be completed, and like given evidence of you fixing the problems and the issues that have arisen.
Hmm.
Also, they would probably test that you have implemented the right things to remediate all of the issues that they have mentioned. So it's more of like if you delay the process of the remediation, it will cause more concern to FCA. And
Sure.
if even if it's like a response that's a bit superficial, that it's not like in detail, that would also raise concern to the FCA.
Mhm.
So I think like the best approach to take when it comes to remediation is to be prompt, like be proactive, show
Mhm.
how you're going to go about it, and so on.
That's really insightful. Prompt action, root cause analysis, evidence of investigation. It's a slightly different approach to what was taken at the SRE during my tenure, anyway. When we identified an issue, we would set the timeline for the firm to rectify it. We would set the specific actions that the firm had to take and the evidence that they had to provide. Although I'm sure the FCA doesn't take just one approach either, it's useful to see the similarities and differences.
Exactly. So there wouldn't necessarily be one approach. It really depends on what the remediation is. Most likely,
Sure.
they would give a timeline.
Building on that, I'd like to bring the focus back to law firms. So, from your experience, what are the more common mistakes financial institutions still make that law firms should avoid from day one?
the common mistakes would be like things that I've seen, especially recently, is like tick box. Like, don't take a tick box approach and don't use too many templates as well. Try to go more in depth with your reviews. You need to be able to use your judgment. Don't have a poor approach or a poor documentation of judgment. You need to fully explain like why something has been done. So there are things like also weak source of funds analysis, that type of thing. So you need to go into depth why the source of funds is what it is, and instead of just like a surface level analysis. There was also like insufficient senior oversight. Like some people may not take that part as seriously as they should, or some firms, sorry. So there tends to be insufficient senior oversight and failing to escalate problems on time. I find that's a common one with a recent headline I read as well. So failing to escalate problems as quickly as possible.
That's really interesting. Everything you've mentioned, the SRE has seen and raised concerns about at some point as well. Things like taking the text box approach and not rationalizing why a specific action was taken where there's weak oversight or failing to escalate issues promptly. It's really fascinating to see the overlap between what financial institutions struggle with and what we've observed in law firms. Building on that, for the firms that want to get ahead of any regulatory shift, if a law firm wanted to be quote unquote FCA ready before any changes actually happen, what would you say are three things they should start thinking about or start doing right now?
Even though like nothing's necessarily in place yet, like there's nothing to say what approach the FCA would take, I would probably say, number one, ensure governance and accountability is clear and documented.
Mhm.
Second one would be focus on quality and consistent files and reviews. Focus on getting them to a high standard and in-depth analysis, and make sure it's consistent across all clients, and explain the evidence that you've also provided very well. And three, I would say make sure that there's good AML management. So make sure you understand the firm's risk very well as well. So not just like activity metrics, make sure you understand the risk that the firm can take and follow from there.
That's really sound advice, Chantelle. It's practical, actionable, and it gives firms a clear starting point even before any formal guidance or changes from the supervisor. So here's my next question. Each year, the FCA issues a lot of attention-grabbing Dear CEO letters. Could you explain what these letters are and what firms are expected to do when they receive one, please?
The Dear CEO letters are basically a formal supervisory comms that often go out to an entire sector. So it's basically shows the area of concern, the types of weaknesses that arise, and the expectations. And it's something that firms should take seriously, because it's basically showing you like the supervisory focus. So once the letter is received, the senior management, they'll review it, they'll assess the framework against it, and they'll, if a remedial action is needed based on what is in the letter, they'll also carry that out, and evidence response. So it's just something that you can use as a focus. Like this, the supervisory board is basically showing you what they are seeing and how you can like make the changes necessary for your firm.
It's really interesting. If something like this were to be rolled out to law firms, it would be completely new for them. And of course, we don't know if or when the FCA might extend this approach to the legal sector. It's useful to understand how financial institutions respond and the kind of attention and action these letters actually demand from senior management. So thanks for that. Okay, so building on that, moving on, if you had to give MLROs or compliance leaders one piece of advice as they prepare for a potential FCA transition, what would it be? I mean, even though we don't know exactly what the future might look like.
Ooh, one piece of advice. I would say probably document judgment and escalate early. I would say that always escalate early. As soon as you can possibly escalate, make sure you escalate that, and recognize your risks and make a decision based on that.
Recognizing your risk and acting early is exactly the mindset that prevents small issues from actually becoming big ones. It's really about being proactive and not reactive. Chantelle, thank you so much for joining us today. Our discussion has highlighted, to me anyway, many of the similarities across the financial services and the legal sectors. And I hope it sheds light on some of the questions law firms may have about how the FCA works. If you found this episode useful, consider subscribing and sharing it with colleagues who live in the world of nuance, risk, and razor thin judgment calls. And if you've got a topic you'd like me to cover, I'd love to hear from you. Thanks for listening to the AML Clinic. Until next time, stay informed and stay compliant.